Hey, and welcome to the EJ Lee Law YouTube channel. My name is attorney EJ Lee of EJ Lee Law Practice, where the motto is to be creatively legal. EJ Lee Law specializes in entertainment, intellectual property, particularly copyright and trademark, and business matters. We're going to get right into it. I'm going to be talking a little bit about copyright, and I'm going to be talking about trademark, and I'm also going to end this talking a little bit about what's going on with the latest Ed Sheeran and Marvin Gaye debacle that's presently going on in the New York federal court. And just so you know, the Gaye family is not the ones that are suing Ed Sheeran right now. It is a co-writer of the song Let's Get It On. But we'll talk about that later, and I'm going to leave a link to an interesting article in the Hollywood Reporter about that specific case, and it also gives some background into the actual plaintiff that is suing Ed Sheeran and how I feel that case is going to be thrown out. But anywho, just to get started, so let's talk about copyright. So with copyright, you get 6 exclusive rights, and I made sure I wrote them down in my trusty little notebook because I want to make sure I'm giving them to you accurately. So one of the rights is the right to reproduce the copyrighted work, the right to create derivative works based upon the original work, the right to distribute copies of the work to the public, the right to publicly perform the work, the right to display the work, and lastly, which is the 6th right, which applies to sound recordings only, which is the right to publicly perform sound recordings via digital audio transmission. So copyright applies to works of original works of authorship that are minimally creative and contained in a tangible medium. So what would be a tangible medium? If you write a book and you have a book manuscript, that would be your tangible medium. Obviously, when you actually get the book, that becomes your tangible medium as well. When you do music and you write down music lyrics, that would be a tangible form. When you record the music in a studio and you have it placed on a CD, that's considered a tangible form. Same thing when you record or filming a TV or a TV show or creating a film. When you put it in tangible form like a tape or a DVD, that becomes your tangible form. So my first rule of thumb when it comes to my clients and they're telling me about the different things that they have going on as it relates to ideas, I always tell them don't share your ideas until you have it in a tangible form, because that is what's protectable. The idea itself out in the atmosphere is not protected until it's written down. Secondly, I also want to point out that when it comes to copyright is to protect original expressions of ideas. It does not mean that you own the idea itself. Now, the example that I'm going to use is not necessarily copyright, but I just want to give you an idea of how ideas work. And what I mean by that is, for instance, the idea of a fast food restaurant. That is an idea, right? But the original expression of fast food restaurants would be McDonald's, Taco Bell, Burger King. So those are the expressions that are protectable. Another example I'll give would be a mouse. Think of a mouse. A drawing of a mouse is the idea, but original expressions of mice would be Mickey Mouse, Minnie Mouse, Speedy Gonzales, Jerry Mouse. Those are all original expressions which are protectable under copyright. So that's what makes it distinguishable. We don't own ideas. We own our original expression of those ideas. With copyright, the moment you create the work, copyright protection automatically attaches to it. The only thing you're required to do is, if you had to sue someone for infringing on your copyright, you would need to register it with the Library of Congress. So it just makes sense to go ahead and just do that anyway. So yeah, that's a little bit about copyright. The length of copyright protection, we'll get into that as well before I go off onto trademark, is 70 years plus the life of the author. Now, there are some times when the length of protection changes, but again, that is the basis of how the copyright law works for works created after 1976, I believe. No, I take that back, about 1978. Don't quote me. Always make sure you seek independent legal advice if you want to clarify that, but I believe it is 1978. So anywho, now we're going on to trademark. So trademark basically applies to a word, a group of words, a phrase, a symbol, even a character that is used for the purpose of distinguishing competitors from each other in the same marketplace and whoever they're marketing to, their consumers. So some examples of trademarks, obviously, again, like I talked about, would be McDonald's and the M, Burger King and their symbol, Taco Bell and their symbols. Those are examples of trademarks and how they distinguish themselves from other fast food restaurants. Examples of trademarks would be Publix, Kroger, Harris Teeter, all different trademarks representing grocery stores, clothing brands or shoe brands, Nike, Adidas, Puma. Those are examples of trademarks distinguishing and for shoes as well. I'm presently rocking Fashion Nova. I love Fashion Nova, but I'm using it as an example to distinguish from Victoria's Secret or New York and Company. But that basically is what a trademark is. And unlike copyright, where the protection attaches automatically, even though you might come up with a trademark, does not give you automatic rights. Your trademark has to be attached to a product or a service. So just coming up with a slogan does not give you any rights. One of the examples I love to use is the on fleek example. There was a young lady who happened to just post a Snapchat video of her saying on fleek, and then the next thing you know, it turned into this big phenomenon where people were saying on fleek in songs, and then next thing you know, you had a ton of trademarks filed for on fleek. The young lady unfortunately did not have any protection in on fleek because on fleek was not attached to anything that gave her any rights to it, even though she coined this phrase. So always keep that in mind. When you have an idea of some sort, even for copyright purposes, if it's not written down, you don't get any protection. And for trademark purposes, if you have not attached that proposed mark, that word, that symbol, that slogan, that phrase to a product or service, you have no rights to it. So with trademark, the length of protection is indefinite as long as you're using it. And again, like I said, we'll talk about those things a little bit more in depth. But over here at EJ Lee Law, those are some of the things that I handle for my clients. I file copyright registrations. I also take care of trademark registrations, and I do brand strategies as well, because the one thing I find with trademark is people don't necessarily understand how trademark works in terms of what makes a strong trademark and what makes it protectable. So we'll talk a little bit about that in a future video if I haven't already. In a prior video, I'm not sure if I did. But again, I'll go into a little bit about brand strategy and how to pick a strong trademark in another video. But I also want to discuss the Ed Sheeran case. So I'm going to pull this up on my computer, and like I said, I'm going to post a link to the article. This article was actually came out on June 28th. And what's interesting is that the company, which is called Structured Asset Sales, that is suing Ed as of right now on their own, tried to join a lawsuit. It says, back in May, an entity called Structured Asset Sales wrote a letter to the New York judge seeking permission to become an additional co-plaintiff in the case over Thinking Out Loud. There's a guy, his name is David Pullman, who is the actual owner of Structured Asset Sales. And what ended up happening is one of the songwriters, Ed Townsend, one of his heirs, I believe Ed Townsend has since passed, Ed Townsend Jr., funny his name's Ed, one of his heirs sold his interest to this company, to that Let's Get It On song. And so they are the ones who are presently suing Ed over this song. My personal opinion, well, before I get to my personal opinion, let's start with how copyright infringement works. To prove copyright infringement, you have to prove access and substantial similarity. Because we are a global society, the access portion is pretty much a done deal, because we have the internet, we have our phones, we have access to music in ways we never had before. So it's pretty easy to prove that Ed Sheeran had access. However, the prong where we're talking about substantial similarity is what's going to be more difficult to prove, because we're going to be talking about, in this particular case, about what is generic in terms of elements that cannot be protected under copyright. Secondly, how because there's nothing new under the sun as it relates to music, it has to be very, very original to be able to get some type of, I would like to say, copyright protection. And so this particular lawyer that filed this case on behalf of Structured Asset Sales didn't really do a very good job of pointing out how this Ed song is so much similar to the Let's Get It On song. So I really don't anticipate that this lawsuit is going to go far. Hopefully Ed and his co-defendants, which includes his record label and publishers, will have this case thrown out, because I didn't hear it. There are certain things that sounds like Let's Get It On, but not enough to me to rise to the level of a copyright infringement case. Now, I will say some of my colleagues and I have gotten into disagreements as to that, and when it comes to substantial similarity, but the elements of proving a copyright infringement case, that is generally a question left to the jury if you can survive summary judgment and where a judge would basically determine that the case is not strong enough to go to a jury. So hopefully Ed Sheeran's legal team can have the case thrown out on summary judgment. If not, then they'll have to go through some discovery, and the case could possibly go before a jury. But I'm hoping that it won't get that far, because I just think this is silly. So again, if you have questions, or if you have comments about what I talked about with the Ed Sheeran case, if you have more questions about copyright, I put together what is called the intellectual property readiness checklist that goes into depth about the copyright process, the trademark process. And if you would like that document, you feel free to send me an email at ejlee.ejleelaw@gmail.com. You can also check out my website, which is www.ejleelawpractice.legal. I've got some great things going on over there, some DIY offerings. So for those who might not be able to afford one-on-one services, you can kind of do a couple different things on your own. And I'm constantly adding different things over there. So please go over there and check that out. And as always, be creatively legal, and I will see you guys on the next one.